So, okay, the next one is advanced parole, which we went over a lot of the points, but just some to highlight here. Advanced parole is a procedural construct. So the inadmissibility section of the Immigration Nationality Act, Section 212 D5A, gives DHS discretion to parole a non-citizen into the U.S. for a temporary period on a case-by-case basis for urgent humanitarian reasons or significant public benefit. Parole is a permission for individuals, even those without valid or expired travel document, blah, blah, such as a green card or U.S. visa, to travel to and enter the United States for a specific reason. It is not considered an admission under immigration law. It's very important to note. The determination of whether a non-citizen is admissible, able to enter U.S. on a visa or entry document without the limitation of parole is not the part of the parole determination. Okay, so USCIS, CBP, and US ICE can grant parole on a discretionary basis. However, this part, since CBP is the final arbiter of whether an individual can enter the United States, a grant of parole by USCIS or ICE merely allows the individual to present themselves to CBP for inspection and ask for permission to enter. Advanced parole is not governed by a specific statute or regulation. It is a procedural device derived from the General Parole Authority in Section 212 D5A of the INA. The process of applying for advanced parole is governed by the form, instructions, and USCIS operational guidance. So you see, it's procedural, so it's much easier for them to do things with it, change it, and it kind of goes to the fact that let's say you have someone. I think thinking about it now, while I'm talking about it out loud like this, if there's an exception that says if you're on an H-1B or an L-1, you don't need advanced parole, you can travel coming forth. And the interesting thing about the H and L is they're dual intent visas. So if you have them and they're valid, you should be able to come even if you have an adjustment case pending without abandonment. About taking that abandonment consideration out of the place, which I'm not sure why they have to have that part of it, but maybe that's statutory. I'd have to check that out. But let's say you came on a tourist visa, you file for adjustment status. If you leave, potentially your tourist visa was overstayed, so it's automatically voided. So to be able to re-enter, you will need parole for that to find a way to re-enter. So that might be a reason why you would need parole. So that's I'm thinking out loud. Hopefully that makes some sense to people listening. But it is procedural. They can do whatever they want with it. Essentially, it's flexible in that sense. So they should just do it.